interim order. When it will expire?
I have made an application.
Okay. Let it appear as to be mentioned.
Application.
Application form?
For the application for claim case.
No, no, claim case, what application? Under claim case application?
Yes, sir. Application after second application. I am for the opposite party. The matter was dismissed for default in 2024. It was the resolution application has been filed. Since then, it is pending. They are not taking it.
Have you served notice of
Yes.
application? Let it appear under the heading application. No, no, inclusion form? Under what heading? No, no, claim case for hearing. It will be included under what heading will it come? Is it ready for hearing matter or application? Yes, what? Ready for hearing or application? Claim case. Anyway, let it appear as to be mentioned.
Second, 2016 matter. The matter to come after.
If the records are here, it will appear under the heading hearing. If the records are, give the slip. If the records are here, it will appear.
This is the second application matter. 2025 May, it was last heard by the registrar Illinois, directed filing of fresh requisites within 2 weeks. The time has expired. Will it appear? There is a change we have.
Anyway, to be mentioned.
To be mentioned, my lords, on Monday.
Anyway, on the date when to be mentioned matters will be taken up.
Great.
Yes.
But may I have your option kindly to mention? Matters my lord, previously heard this matter and fixed for hearing. My lord, kindly keep it in the list.
It was earlier heard.
Earlier. Let the comments to be mentioned, my lord, then we can
Yes, give it.
deeply of it. I was hearing my others.
Hearing?
Yes,
Yes, after 2 weeks.
Yes,
Yes, yes, call the list.
Application number 1, item number 128. 28. 28.
Yes.
All of the claimants, number 2. Claim number 2 will die for the attain maturity. And not the other number 3. Number 3 will die, but you know, number 3 comes and number 3.
The other years are already on record.
Number 2 will have added majority, but she has got married. She got married.
And which respondent died? Applicant died?
Number 3.
Yes, record and order. Learned advocate for the parties at present. This is an application filed by the appellant for recording the death of appellant claimant number 3, Muhammad Rani, and for recording the change of name and address of appellant number 2, and also for recording her majority. It is the contention of the appellant that the appellant number 3, Muhammad Rani, died during the pendency of the appeal, leaving behind her the other appellants as legal heirs. Thus, the name of the appellant number 3 be deleted from the cost record. So, with regard to the appellant number 2, as the said appellant has attained her majority as reflected in the Aadhaar card, let the majority of appellant number 2 to be recorded, along with her change of name, change of the surname. Stop. Let the name of appellant number 2 be recorded as Borsha De Shaha and her majority be recorded. The department is directed to carry out the amendments within 2 weeks.
And dispose of it.
Yeah, and
And for the amount of,
it is clarified that the compensation awarded be distributed among the claimant respondent number, claimant appellant number 1 and 2.
29. Below the 29.
Just a minute. Have you filed the death certificate of the? That is also filed. Okay.
Below 29 is below the claimant's fee. Below for the death of their below 28-year-old bachelor son, below the parents filed claim case under 163. But it was accident was in the year 1998. Today is below 30 years. Below learned tribunal judge awarded below 1,96,500. Insurance company paid they have received. Below they have come up for enhancement. Below 163, they will get 5 lakhs. Below this is 30-year-old.
What is this application? Can one?
Below canvas below is for condemnation. You can dispose of the bill below 30-year-old accident below 163A. They have received 196,500.
This is section 5 application. There was no direction for any paper books also.
No direction for paper.
Where is that application? Okay, this can one, how many days delay?
695 days delay, my lord. My lord, it was 6 per day, and my lord, the execution it was pending for 3 years, more than 3 years, my lord. Any court cases, my lord, without court part was there.
Below it can be below the disposed of below 5
Okay.
lakhs.
1,96,500. So both the appellants are alive now.
Yes, sir. Father and father are alive.
Your
Your Lordship will record.
Yes.
Your Lordship will record. They have received the sum awarded by the judge.
Yes, record and order. Learned advocates for the appellants, claimants, and learned advocate for the insurance company are present. The service of notice upon the respondent number 2, the vehicle owner is dispensed with. The application for condonation of delay is taken up for consideration. Hard learned advocates peruse the petition files. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned, and the appeal is admitted. Stop. As the respondent number 1 insurance company is represented today by the consent of the learned advocates, and the appeal is taken up for hearing. Hard learned advocates for the parties peruse the materials on record. This appeal is directed against the judgment and award dated 30th June 2011 passed by Learned Additional District Judge, Second Court, Kishonodia in MACC number 541 of 98. Stop. The learned trial judge, by the judgment and award dated, was pleased to award compensation of rupees 1,96,500 to the claimant's appellant. Stop. The appellant's claimants being aggrieved by the quantum of compensation awarded by the learned trial judge has come up with the instant appeal for enhancement of the compensation. Stop. Upon hearing the learned advocates and considering the facts of the case and the provisions under section 163A of the Motor Vehicles Act 1988 and that of recent amendments, and further considering that the motor vehicles claim legislation is a beneficial legislation, this court is of the view that in terms of the latest amendment, the appellant's claimants should be awarded rupees 5 lakh compensation. Stop. It is submitted by Mr. Singh, learned advocate for respondent number 1 insurance company, that the compensation awarded by the learned trial court is already paid.
It has been allocated by the.
Has already been paid, and which is not disputed by learned advocates for the appellants. Stop. The facts and circumstances, this appeal, FMAT
1049 of
2013 stands disposed. The judgment and award dated 30th
June
2011 stands modified to the extent that the appellant's claimants will be entitled to receive 3,0500 along with interest at the rate of 6% per annum from date of filing of the claim case till today. Stop. The respondent number 1 insurance company shall deposit rupees 3,06,500. 6,03,500.
3,03,500.
The respondent number 1 insurance company shall deposit rupees 3,03,500 along with interest at the rate of 6% per annum from the date of filing till realization before the Registrar General, High Court, Calcutta, within 8 weeks from the date of communication of this order. The appellant's claimants will be entitled to withdraw the compensation upon compliance of the necessary formalities. This appeal stands.
We're extremely grateful to my Lord's kindness. I'm a best.
Lordship, this is under 163A. What I was beseeching my lord, I just go through the matter once. My lord, if it can be disposed of, Lordship kindly pass it over. If after 12 o'clock, my lord has put matters fixed. So if it can be taken up,
Let it retain its position. Okay.
let-
Let it retain its position. I'm just making it not today. On the next day, I shall take it up.
Along with the application.
along with the application, if it can be disposed
Yes,
of, it can be.
I'm just making it not today.
Recording argument of majority. That is all.
That is your record. Just not today.
My lord, great.
31. 31.
Yes. How many days delay? Yes, record an order. Learned advocate for the parties are present, are learned advocates. This is an application for condonation of delay filed by the appellant. So, upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preparing this appeal is condoned and the appeal is appealed. As the learned advocate for respondent number 1 insurance company is represented, service of notice upon respondent number 1 is expressed with. Yes, has the trial court records come? I not require. So many disputes are arising. We have to peruse the trial court records.
Quantum matter, I have served paper.
That also trial court records are required. Have you enclosed all the documents?
Yes.
As the paper books are filed, let the same be kept with the record. The service of notice upon the respondent number 2 vehicle owner is dispensed with. Let this matter appear for hearing on 1st August 2026 at 10:30 a.m.
I'm appealing on behalf of the applicant.
This is my application.
No, who is you are the appellant?
I'm for the applicant, madam.
Yes,
But there are
Application filed by the claimants.
yes.
Well, the claimant.
I have not been served any copy of
You are for vehicle owner to serve a copy.
Mother, it's for the owner. Like these rights are not important.
Anyway, he is a party to serve.
Because although the one inconsequential, I'll give him a copy.
Okay, can only take up.
Yes, Mother, claimant respondent is in the injury case, has died. I have filed 2 applications for amending the cost title and substituting the legal heirs. Let the correction be carried out as per paragraph 9.
Can one.
Can 1 of 2023 is my application for stay, madam. The stay has to be made absolute because I have deposited.
Yes, record and order. Learned advocates for the parties are present. The application for substitution filed by the applicants is taken up for consideration. Our learned advocates, there is the petition file. It is the contention of the application that the respondent number 1 claimant died during contention of the appeal, leaving behind the applicants as mentioned, leaving behind the applicants as legal heirs. In the facts and circumstances, this application stands allowed. The name of the respondent number 1 claimant be deleted from the cost title and the name of the applicant's legal heirs be incorporated in their place and state. As mentioned in paragraph 6 of this application, Can 2 of 2024.
Yes.
This application stands allowed. The amendment be carried out within 2 weeks by the department. So, as the appellants have deposited the entire compensation amount, the editorium of order of stay granted earlier shall continue to disposal of this appeal. Yes,
Well, let the correction be carried out in terms of paragraph 9. I have mentioned the address of
let the department to carry out the amendments in terms of paragraph 9 of the application within 2 weeks,
yes.
as well as the incorporation of the legal heirs in the cost.
Well, this is with regard to Can 1.
Yes. No, Can 1 is stay.
No. My lord,
Can 1 of 2023 is stay
Yes.
and
Can 1 of 2024 is
Can 1 of 2023 has to be disposed
I
of.
have disposed of Can 2 of 2024
Yes.
and Can 1 of 2023. They made absolute and the substitution allowed.
Well, let this correction be carried out in the appeal as well as the cross objection.
Yes, the necessary amendment to carry out the appeal as well as
copies of all these
The cross objection
to serve upon it.
is
yes, as the respondent number 2 vehicle owner has appeared, service of notice upon the vehicle owner is dispensed with. Necessary service be effected upon the learned advocate for the respondent number 2.
there is a cross objection which is not there in the list. Court 6 of 2024. Let that be tagged on.
This appeal be listed along with the Cross objection, COT. COT, how?
6 of 2024.
6 of 2020.
And further, kindly pass a direction for filing the paper because I have all the certified copies.
All these directions are there in your lordship's previous order.
Yes, you will be filing paper.
I'll be filing.
Trial court records are come.
Yes, informal paper. I'll be filing.
In the request.
I'll also give the special messenger cost.
The trial court records they call for at the special messenger cost of the respondents claimants. The informal paper book be prepared on arrival of the trial court record. Liberty to mention after 4 weeks.
Deep leverage.
43.
Yes, your for the appellant is the matter. Paper books ready? Yes. What is this Calgon? How many days?
1 to 3 days.
Yes, you have been served with the copy.
This is the
Order for opposition long time.
Are you opposing this section 5?
yes,
You want to file opposition to this?
yes, ma'am.
Time may be extended. Already there is a direction.
You have not filed your opposition. There was an earlier direction.
Just this is the
Okay. Learned advocates for the parties are present. It's time to file affidavit in opposition. Stand extended till 16/7/2026. Reply if any by 20th July 2026. Let this matter appear on 23/7/2026. Under the same heading.
Thirty-four to 36.
Father and mother of the by filing ballot on constitution.
No, what is this? Can 2 and 3?
It is my application for withdrawal of the amount deposited by the insurance.
You are representing who? All the claimants.
No, father and mother of the deceased is declaring
The widow.
Yes.
Respondent number 1, widow.
You are praying for what? Withdrawal.
Withdrawal of the certain portion of the awarded amount.
Is the challenge with regard to quantum only?
No, some other points are also involved. What will fix up the date for hearing of the appeal?
You see, if the appeal cannot be taken up, and if the challenge is only with regard to quantum, then
because lordship's matter already held that in favor of the claimants, the other matter last month your lordship
that's
delivered
a
this.
different issue. What I am confused. What I am saying is-
Fix this appeal, Milord, this month, next month, any day, subject to my lord. Can you dispose of the appeal?
Yes, that I can do. But you see, sometimes you see, if it cannot be disposed of,
Quantum, Milord.
if it is quantum, if the appeal cannot be disposed, then so other points are there. Yes, record an order. Paper books are ready.
Yes, yes, sir.
Yes, record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books filed, let this
Of dispose of bills.
condonation application is there.
That is file of the insurance company. His appeal is reviewed.
Yes, Mr. Singh, your condonation application is disclosed.
Milord, I have pursuant to my lord's earlier order, Milord, I have
No, maybe, but prior to that, your section order will carry the otherwise entirely it will be defective. You see, it must be, there must be some order.
Yeah, this claim was made absolute, Milord, this is what my condition is.
I'll be called on the delay matter.
Milord, your worship, can you pass it over? Milord, I'll take it up with
Okay, pass it over.
And they will put everything in. Proceed here, this is the conventional delay.
And one,
Yes, sir, yes, sir. So is the actually 14 days delay. My permission to the delay of 14 days.
okay, it is your appeal.
My appeal is include this, that service certificate there.
Yes, record on order. Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates. When the petition filed for hearing the learned advocates and about the petition, the court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preparing the appeal is condoned and the appeal is admitted. As the respondent number one insurance company has appeared, notice of respondent number one is dispensed with.
Both responsive did not appear.
Vehicle owner did not appear. Moreover, as the vehicle owner did not, respondent number two did not contest before the learned trial court,
Yes.
the service of notice of the vehicle owner is also dispensed. Your filing paper book, let the paper books file be kept with the record. As this matter is ready for hearing, let the same appear for hearing on 1/8/2026 at 10:30 AM.
Madam, Mr. MP Chakraborty actually is appearing in this case.
Another date, my lord. Kindly.
What?
Mr. MP Chakraborty is senior. Is senior. So Mr. Chakraborty is not present. So also kindly any date after month. So Mr. Chakraborty is not present.
Let the date will be fixed in his presence. I'm just directing to appearance to be mentioned on the next week. Acha. Let this matter appear under the heading to be mentioned for fixing the date on 15/7/2026.
Not today.
38 anybody present? Yes, not today. All the passover matter.
Madam, delay was followed.
34 to 36. Delay condom আছে man.
Malodin piece of date.
Yes. That is item 37,
34,
35, 30. Yes, record on order.
Malad, only one request. The point of law which Mr. Singh has taken, it has already been
Very
decided
well.
by the Lord.
Learned advocates for the parties are present. As the paper books have been filed and the matter is ready for hearing, let the matter appear for hearing on 1st August 2026 at 10:30 AM.
Malad,
It can be before that.
No. That date I don't have many matters. Okay, I can do it or take it up on that day.
we don't have any difficulty.
Yes.
Stay nearby,
Yes.
we can come.
Yes,
There is a high probability, Malad, on that day, a resolution will be.
very well. If both of you are present, no, but the bar association will not prevent anybody. If parties are all present. Very well. It will be a very light day. Matters can be taken up.
Can it be on board?
No. For the timing, let it be on first.
Or before that, Malad?
You don't have the diary, that's not part. For the timing, I'll keep it on that day.
39.
Let's say add for the appeal.
39.
39. Lordship delay, this is Lordship 163 application delay about Lordship 770 days. Kindly consider. I have explained the petition Lordship. Another
Is your appeal? Yes, learned advocate for the parties are present. The application for confirmation of delay is taken of course in consideration are learned advocates. They will be petitioned by how many days?
769 days.
Upon hearing the learned advocates and considering the petition filed, this post of review that sufficient ground is found for concluding the delay. Thus, delay in filing this appeal is controlled and the appeal as
Second, another matter is on 160 and your losses.
as the respondent number one insurance company has entered appearance, service of notice upon the respondent number one is dispensed with. Moreover, respondent number two contested before the trial court. Moreover, as the respondent number two has not contested before the learned trial court, service of notice upon respondent number two is also dispensed with. By consent of the learned advocate, the matter is fixed for hearing on 22/7/2026. At what time did I fix? At 12 p.m. The paper book file we kept with the record. No, 22 तारीख order से
Okay.
40 years. What application?
40. After the claimant responded, you have prepared the paper book. That copy I have served upon Mr. Singh. It's the only point subject to submission of Mr. Singh, which I have gone through the grounds of the appeal, is simply or challenge the quantum. He deceased was the Lordship Army personnel. So, and the learned tribunal considered the income 40,000 per month. That is a very usual. But again, that Mr. Singh for an appeal, he can.
Okay. See the appellant.
It is so yes, Mr. Singh is
There is no cross objection.
there is no cross objection.
Paper books are ready.
Usually that has all.
Transport records have come.
Not required Lordship, all the certificate to be I have it. The certificate to be I have it. It is not that apart from that there is no
Transport records, there is some difficulty. Sometimes many documents will be saying.
kindly Lordship, kindly take the tomorrow or day after tomorrow. If Lordship is difficult, then call for.
Matter which requires hearing. See, even if it is quantum, the matter requires hearing. It's not 163A.
No, 166.
Yes, record and order.
Lordship, record is not required because of Lordship. I have Lordship kindly here. Well, record is there.
Trial court record.
Yes.
Okay. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books filed, let this matter appear for hearing on 1/8/2026 at 10:30 a.m.
What you want? Not today. This is an application for recovery based off of the application number 2. Under the application was this two. And the insurance company has complied with the order of.
They have deposited.
They are deposited. And whether there are 5 payments appealed. Out of 5 payments, whether 1 payment died. That is the application number 2. And on the and also 1, 3, 4, 5 have withdrawn their share of compensation.
Who died? Which level?
Appeal number 2, money. Only Devi Agwa. Under page 10, your Lordship kindly say, the date certificate I have added.
Okay.
Mother,
Died living there in which years? What are the legal heirs?
They are the surviving legal heirs. Mother,
The
only
legal heirs are already on record. So simplicity of the name has to be deleted.
has been expired.
And
And mother, their portions of share of compensation be manner given by the office of the register general to other manner can be
What the which paragraph you have stated?
manner you logic kind of manner paragraph 2.
Yes, 1, 3, 4, and 5. 1, 3 being the appellant number 1, 3, 4, and 5. Paragraph 4.
Paragraph 2. The name certificate I have added to paragraph 3. That is the matter issued by the register birth and date of Howrah Court. Other date was occurred on manner on 2nd October 2002. Just manner and I have also paid.
So this 1, 3, 4, and 5 are yet to receive the compensation.
Here,
Yes, sir.
manner the share of compensation which manner the manner was made ready by the office of the Register General. Of 5 demand drafts have been made by the office of the Register General. Out of 5, 4 have been withdrawn. Only since manner he died, manner their share of
That is 1, 3,
compensation
4, and 5 are to receive the compensation in equal share. Yes, record an order. Learned advocate for the applicant is present. It is the contention of the applicants that the applicant number 2 died on 2/10/2024, leaving behind the applicant number 1, 3, 4, and 5 as legal heir.
Had died 2/10.
Leaving behind the applicant number 1, 3, 4, and 5 as legal heir who are already on record in the present case. Stop. In the facts and circumstances, name of appellant number 2 is deleted from the cost record. Stop. The department to carry out the necessary amendments within 2 weeks. The compensation amount to the share of the appellant number 2 shall be distributed equally amongst appellant number 1, 3, 4, and 5. Yes, 42. And 2. You are representing who died? Respondent number 1.
Other of the Sudirma.
Okay, Sudhir Mal.
Respondent 2 already died.
So respondent number 3 died, leaving behind which legal heir?
Legal as a Nelson Miller, Sonjima, and Pujama, son and daughter. Para 1 minor. Can 1, can 3 times para 1.
Moving on and Pujama. Father of the victim.
Yes, father of the victim.
Father of the victim died. Okay. Father of the victim died. Now the question is,
Mother also died before that. Mother also has a party. Died before the kind of.
Father is not a legal year, it's not a year for first class, yes, he's not a first class. So he's not entitled for claim.
Mother also claiming that one of the claimant is their minor. To the tribunal court. Mother name has been expunged.
No, another thing is this. Anyway, let them be substituted at the time of compensation. This issue will be taken up.
Wife of the deceased daughter is
They
alive.
are only entitled now. Wife, daughter, and father. Mother already expired.
Yes, sir.
Now the question is, after the date of mother, it was expunged.
Yes, sir.
Now the question is, father died, and these are all brothers and sisters.
Yes. They are entitled to claim compensation.
Actually, if father is entitled, then automatically after his death, it will go to the other heirs. That is where
That is the first class year. No, that not the first class year. He is the second class. So, he is not entitled. When the wife and son is the
Dependency arise also.
no. You are
not arise.
no question is your client, that is this Parul and this. Is she objecting to this brothers and sisters getting share of compensation? Because you say ultimate outcome will be they have to get the compensation to some extent at least.
Claimants are filed the wife, minus son, and minus daughters and parents.
Yes, record an order. Learned advocates for the parties are present. Are learned advocates. This application is filed for recording the death of respondent number, appellant number 3. Stop. As the appellant number 3 died, leaving behind the legal heirs as the present applicants, we are made parties without prejudice in the right of the appellant number 1 and 2 with regard to the eligibility to claim compensation. So this point will be kept open. These two applicants, right? The name of the respondent number, respondent number 3 be deleted from the cost title, and the name of the applicants, Parul Mal and Paidor. Name of the applicants, Sanjeev Mal and Pooja Mal, be incorporated. The name of respondent number 3 should be deleted from the cost title, and the respondent number and the name of the applicant Sanjeev Mal and Pooja Mal be incorporated in their place and state. This is without prejudice to their rights about their eligibility to claim compensation. This point is kept open at the time of argument, whether they are entitled or not.
Minus paper already filed.
Yes, have you filed paper?
Already filed.
Okay.
I the document. Issue for
The department to carry out the amendment within 2 weeks, liberty to mention thereafter.
My application extension of it was passed on 5 adoption. Thereafter, the matter had of January. The adoption had extended the implement for 10 weeks. Till 31st of March. The application has been was supposed to appear. The matter was supposed to appear on 2nd of March. But it did not appear your option. So it had filed an application on 31st March itself for extension.
No, what was the interim order passed?
Whatever passed.
Let us see the interim order.
application.
Cancel.
Appropriate order. Then put the appropriate order.
In extension to put.
Set page number 8. 8. Can go.
এর আগে থেকে এক দুই তিন এই ক্যান গুলো কিসের? এক দুই তিন ক্যানটা কিসের?
Can 2 is stay application. Can 1 is the stay application. Can 2 was an application of additional documents from the tribunal, and Can 3 was for extension, which has been disposed.
Can for another not been served up to us.
Can go for extension. Okay, now what are these other applications for? Can one, can
Can 1 is stay application.
stay application two?
Can 2 is for bringing on record additional documents from the tribunal resolution, and Can 3 is an application for extension of interim order, which has been disposed of.
As well as can four.
Yes, yes. Can 4 is the present application for extension.
So let this appeal be heard of, and this application for bringing additional documents be heard out along with the appeal.
Yes, you have to kindly fix the date, and paper books are also ready.
Paper books are ready, so let a date be fixed for hearing of the appeal.
And kindly extend the interim.
Yes, record an order. Learned advocates.
Paper book has not yet been served.
Yes. Will be served today. Learned advocates for the parties are present. As the paper books are already filed,
Paper books today we
as the paper books are ready, let the matter be fixed for hearing on. দেখুন তো কবে দেওয়া যায়? 4/8/2026 at 2 p.m. The application for bringing additional documents shall be heard analogously with the appeal. The interim order granted earlier stands extended till disposal of the appeal.
What's the disposal of it?
Forty-four is insurance base, but the stay has been made absolute. Today is an application on behalf of the respondent claims. This is for deletion of the name of respondent number 2 in the instant. Claimant respondent number 2.
The two insurance company.
No, there are two insurance.
Okay, you are appellant. Respondent number 2 is Jampuna Ramana Kumari.
Not sure. She is the mother of the deceased. Look, original, your worship will kindly have a look at the original constitution of my memorandum. My lord, original constitution in my memorandum.
এই মেমোটা দিন তো।
Assessing that memorandum, original constitution. Lord, for the death of one Lord Jampan Akiran.
So at present, respondent number 2 hearing.
No, just a second. Lord, there were 3 claimants: widow, mother, and brother of the deceased. Respondent number 1, 2, and 3.
originally.
Father and brother of the
Lordship, that is there in my post ID. Lordship has seen that. Lord, respondent number 2 was the mother. She died. Lord, she was replaced and was substituted by the father of the deceased, her husband. Lord, that is by way of an order dated 17/11/2025. Respondent number 2 died earlier during the pendency of this appeal. She was replaced by her husband, that is the father of the deceased. Respondent number 2 had already been replaced.
that is 2A, Jampana Nagaraju.
Lordship.
Only Jampana Nagaraju. Father.
Yes, my lord. Father Jampanana Nagaraj. Then, my lord, now today, this respondent, the replaced, my lord, substituted respondent number 2, the father, he has also.
So the claim cases of this Bardhaman district,
Lordship.
but the claimants are of Andhra Pradesh.
Yes. So, my lord, respondent number 2, the substituted respondent number 2 has died. So, this application can for today before your lordship. Notice for taking note of
That is respondent number 2A died. 2A died living behind the years. That is respondent number 1 and 3.
I'm grateful. Yes, my lord.
Yes, record and order. Learned advocates for the parties are present. This is an application filed by the applicant, respondent number 1 and 3, for deleting the name of respondent number A, Jampana Nagaraj. It is the contention of the applicants, respondent number 1 and 3, that the respondent number 2A, Jampana Nagaraj, died during the pendency of the application, leaving behind the respondent number 1 and 3 as legal heirs. Thus, this application stands allowed. Let the name of respondent number 2A, Jampana Nagaraj, be deleted from the post-title. The department to carry out the necessary amendment to the liberty to mention.
Yeah.
45, okay, not today.
46.
And for the
I'm for the
there is an application matter about the merger matter.
Let me see.
Can score of it.
Can code. The other application 1, 2, and 3.
I have
I have tried. I have even that.
And 1 and 2 are disposed.
I know. And this
Yeah.
can be disposed of when kindly
The 3 and 5 by the equal Excel will have to pay at least by the certain some amount by the.
That is for withdrawal of amount.
Yes.
it can be disposed of when no need of.
No, in the week then if it is some or a cost that may be this manner.
So, is the challenge only with regard to the quantum or other issues?
WC agreement.
So, it was admitted by the division bench. No, maybe, but only are you challenging the quantum or there are other issues?
There are others. Can be replaced by not can be disposed of. Then I'll prepare the formal paper.
How soon can you prepare the paper book?
It's very
Next week can be disposed.
Yes, learned advocates. Yes, let me take up your canned food. Yes, learned advocates for the parties are present. This is an application. The application for canned food of 2026 is taken up for consideration. This is an application by the applicant Indusing General Insurance Company Limited. Indusing, Indusing, General Insurance Company Limited. On the ground that the appellant Reliance General Insurance Company Limited is merged with Indusing General Insurance Company Limited. So, the applicant has enclosed the order of the Insurance Regulatory and Development Authority of India, showing the change of name. The facts and circumstances, this application stands allowed. Let the name of the appellant be deleted and the name of the applicant Indusing General Insurance Company Limited be incorporated in its place and state. The department to carry out the amendments within 2 weeks. Let the paper books be filed within 2 weeks. Let the matter appear on. Let the paper books be prepared within 3 weeks. 2 weeks. Informal paper books be prepared within 2 weeks. Let this matter appear on 1/8/2026 at 12 p.m. 1/8/2026 at 12 p.m. Yes. There will be very few matters, so you can do it. I kept it at 12 p.m. also.
47.
Yes, working day. Definitely you are aware now. So make your time, okay? Leave other work, make your time. No, other days I have some difficulties. You try if you are unable to come. Yes, I know that. So for one day you make it. Yes.
আমাদের যাওয়া ছিল না if it is not hard to Saturday বেলা the matter will be on the minor
So you attend all days. I know that you go there, but you go all third Saturday. আচ্ছা ওটাকে ইয়ে করে দিন ওটা আচ্ছা ইয়েতে দেখুন তো 31st আচ্ছা 31/7/2026 at 10:30 AM না 31 তারিখে 10:30 31 তারিখে তো কোনো ফিক্স হয়েছে আচ্ছা 12টায় তো তারপরে তো অরিজিনাল সাইজ ধরে নিতে হবে আচ্ছা 30 হ্যাঁ 31/1/2026 at 11 AM 31/7/2026 at 11 AM.
yes I have that 47
Not 47 is insurance appeal surveying for the first time. I was paying for it. Signal there was a TV. So you can share the service and deposit to signal.
Yes. The report to the
Prepare forward the reports.
yes, record and order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. The affidavit of service filed be kept with the record. The service is complete, definitely.
I have served at the address given, in cost I think, in some of the cases it has come back. Otherwise, in some cases,
In which, no, how many claimants you have served? All.
just I have served each and every respondent, including owner, everybody.
No.
I have served all respondents, all claimants.
How many appellants have returned?
Service again.
Otherwise, it will not be a good service if it is.
But this is confirmation of delay application. The address which was given in the first cycle, in the claim application as submitted. They are not there, they are not there. But it has unsolved, with the remark unclaimed, it has come.
Yeah. Learned advocate for the appellant is present. Although notice was issued upon the respondents, all the respondents, but some of the envelopes have returned with the remark unclaimed. Stop. However, in the interest of justice, the service is dispensed with, service upon the respondent is dispensed with only for the purpose of this application. The application for confirmation of delay is taken up for consideration at learned advocate. Wherein the petition filed. How many days delay?
416, 416.
Upon producing the petition and upon hearing the learned advocate, this case is the view that sufficient ground is shown for concluding the delay. Thus, delay in preparing the appeal is controlled and the appeal is admitted. The application for stay is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 17th January 2024, passed by learned additional district judge, 5th court, Alipur, South 24 Pargana, in NSC case number 32 of 2013, for a period of 5 weeks. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding statutory amount, as directed by the learned trial court within 5 weeks. So, in the event the entire awarded amount, entire compensation amount is deposited within 5 weeks, the interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondent, both personally as well as through the department by filling up necessary requisites. The trial court records be called for at the special messenger cost of the appellant. The paper book be prepared on arrival of the trial court records. Liberty to mention after 4 weeks. Controlation of delay dispute. Data pending থাকছে।
Article number 31 is not after Mr. Bahari and Saturday is not come, and also I am going by Mr. Bahari does not tell
You will adjourn it on that day for unable to come.
Nothing. The observability involvement. There is no evidence. Even if they have put nothing, I prepared the paper that we are stopped. You will see everything. I am filing this paper. Yes, so can you fix the matter for any date? I file an application for express hearing that can be disposed of along with the
So this is guarantee for?
guarantee for the application for experience with that. The committee.
Learned advocates for the parties are present. As the matter is ready for hearing and the paper filed, let this matter appear for hearing on 1/8/2026 at 12 p.m. 1/8/2026 at 12 p.m.
Already 5-6 matters I have already.
You see, when you are claiming urgency, make some time.
I am not any disputing. I'm happy with it.
Very well. First have to try to devote some time thereafter.
Kindly, I want submission. Kindly, direct Mr. Sitting to ensure his presence. But he is
So,
already.
So you don't have any faith upon him.
No.
Yes, some direction.
I believe. Yes, he has. I believe he has not. So Lordship, kindly direct Mr. Singh to be present because of already 4 matters already been Lordship.
All my matters are being fixed on first Millard.
So very, I have, till now I have picked only 3 matters. The fourth, this is the fourth one.
Yes, so I believe Lordship, Mr. Singh will.
My item number 34, 35, 36.
No. Just one matter I have just.
Millard, I'm talking about today's list, Millard, item 34 to 36, fixed on first, my matters. Item 40, fixed on third, and then again, Millard, this item 48 is fixed on third.
So how many matters of yours I have picked on first?
Millard, 3 matters together and then one and one, Millard, in.
Very well, no more matters on first.
Millard, I have to prepare.
No further matters on first.
49. So Mr. Singh will present.
Yes.
Millard, 49 is, it shows the fee.
Yes. Application for
Application that I have filed, perhaps the 2 for Mr. Singh. I don't know, yes.
who is for?
Stay has been made absolute, Millard.
Yes, can
We
three?
kindly see the last order and dispose of the all applications, that application for withdrawal of the awarded amount that can be heard along with the application. And Lordship, in this case, Lordship, Mr. Singh challenging only the quantum. Because of his, is the 90% level person, the medical board issues the certificate copy of that.
Very well, paper books are ready.
Papers put ready, the only.
The parties are present. As the matter is ready for hearing and the paper book filed. As the matter is ready for hearing and the paper books are ready, let this matter appear for hearing on. देखो कब 3 तारीख ना कब है?
বলেছি না রেকর্ড হলো কি হবে কাজ করতে হবে মিলে গেছে
देखो 3 तारीख कब है? 3 तारीख by 31 तारीख 5/8/2026 at 10:38.
just paper book we check with
The paper book file we keep with that. Okay, just a minute. On 5/8/2026, probably it is Monday. Tuesday. Okay. Then
50. Millard, 50 is insurance appeal is appearing for the first time before Lordship. Millard, as joint ventures. I made this certificate.
it will stay as well as condonation of delay.
Yes, Millard, my.
You are for?
On behalf of the vehicle owner. And the claimants have received.
Learned advocate of the applicant and learned advocate for the respondent number 8 at present. The application for condonation of delay being Can 2 of 2026 is taken up for consideration. Our learned advocates peruse the petition file upon not Can 2, it a Can 1. Our learned advocate peruse the petition file. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preparing this appeal is condoned and the appeal is admitted. The affidavit of service file is kept with the record. Respondent number 8 is present. None appears for respondent number 1 to 7 in spite of service of the application for stay being Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of ₹25,000, there shall be an adequate order of stay of judgment and award dated 9th day of August 2025 passed by learned additional district judge Hartford MSC case number 229 of 2017 for a period of 5 weeks. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ante-interim order of stay shall continue till disposal of this application. Stop. The trial court record to be called for at the special messenger cost of the appellant and the informal paper books be prepared on arrival of the trial court records. As the respondent number 8 vehicle owner has appeared, service of notice upon the respondent number 8 is dispensed. Service upon respondents number 1 to 7 be effected personally as well as through the departments by filling up necessary requisites and forms. Liberty to mention after cookies.
Bless. The order for investment.
Liberty to mention after 4 weeks, Registrar General is requested to invest the compensation deposited in a fixed deposit of a nationalized bank, interest bearing account, and reduce the same from time to time.
The same direction was perhaps missing in item 47. Sit out investment. Perhaps it was fallen from your lordship order dated of the trial for 9 hours. It is 19 hours. What was the tribunal?
The cost title that was reflected. We say the judgment and award dated
9th August
19th August.
This should be 19th. 19th August. Extremely well.
Islam.
Well, I'm appealing on behalf of the applicant insurance company. This is my affidavit of service. My 10-1 is my application for condonation of delay. I've deposited 25,000.
Yes, record an order. Learned advocates for the appellant and learned advocate for respondent number
Respondent number
1 to 6 claimants are present. The application for condonation of delay is taken up for consideration. Our learned advocates peruse the petition file. In perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is advocated. Stop. The application for stay being canned 2 of 2026 is now taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 23rd day of May 2025, passed by Lane, Additional District Judge, First Track Court, Studi Birbhum, in MSC case number 450 of 2022 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within 5 weeks. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this appeal. The Registrar General High Court Calcutta is requested to invest the compensation amount in a fixed deposit of a nationalized bank interest bearing account and renew the same from time to time. The appellant, as service is already effected upon the respondent number 1 to 6 claimants, service upon the said respondents is dispensed with. Yes, did the respondent number 7 contest?
The owner, my lord, I've served upon him also. It has come back with the remark, no such person in this address. I'll put in Talabana and return of notice.
Now the section
7.
My lord,
7 appeared. You did not contest.
I just check.
Or is there any liberty for
I will check.
recovery?
The point involved in appeal,
No, it was, he did not contest.
involvement of the people.
Only the involvement.
No, there's quantum also.
I am filing the
The service of note as the respondent number 7 did not contest before the learned trial court. service of notice upon respondent number 7 is dispensed with.
No, I will put in the 11 written up notice form. I've already served 11. I shall once again put in.
The appellant shall take steps for causing service both personally as well as through the department upon respondent number 7, vehicle owner. The trial court records be called for at the special messenger cost of
Usual
the
course,
appellant.
yeah.
No, in other matters I am directing special messenger cost. Special messenger cost to be put in within 1 week by the appellant.
2 weeks.
Within 2 weeks by the appellant. The informal, you have prepared.
Yes, I have already filed and one copy has been served up to
Acha. As the paper books have been filed, let the same be kept with the record.
My
Liberty-
lordship kindly fix the date, my lord. My lord, it is only the point which has been proved by the eyewitness. First August, your lordship kindly fix the date.
Okay, liberty to mention after 3 weeks.
My lord, let it appear as let it appear as
Mention after 3 weeks. I
my lord,
include that.
mention, my lord, 60 matters, my lord, are lying in your scope. I mentioned the
This is a
matter.
25. This is not an old matter.
My lord, the 27 lakhs and my lord, the interest around my lord 40 lakhs.
Acha, let this matter appear as to be mentioned after 3 weeks.
I'm sorry. After 5 weeks, because my lord, I have to deposit the money.
Let this matter appear as to be mentioned after. Then after 5 weeks, let it appear as hearing.
My lord,
Let this matter appear for under the heading hearing after 5 weeks.
lordship.
My lord, kindly fix the date, my lord. After
I am
5 weeks.
fixing it for hearing.
My lord, kindly fix the date, my lord, in the month of August.
It will appear under the heading hearing, thereafter it will be fixed.
I'm pretty sure.
Yes. Learned, your court service.
Yes.
Learned advocates for the appellant is present. Let the affidavit of service file be kept with the record. The application for consolidation of delay is taken up for consideration. Our learned advocate for the appellant prepares the petition file. Upon perusing the petition and hearing the learned advocate, this court is of the view that the appellant has furnished sufficient ground for controlling the delay. Thus, delay in reference to the business control and the application. The application for stay is taken up for consideration. Statutory amount you have deposited. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an addendum order of stay of the judgment and award dated 5th January 2026, passed by learned additional district judge 7th Court Barashat, North 24 Parganas, in NACC number 765 of 2018 for a period of 5 weeks. The appellant shall deposit the entire compensation amount, excluding the statutory amount, along with interest, as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the addendum order of stay shall continue till disposal of this application. The appellant shall take steps to cause service of notice of the respondents both personally as well as through registered post. As personally as well as through the department by filling up necessary requisites. The trial court record to be called for at the special messenger cost of the appellant to be deposited within 1 week. In 2 weeks, the informal paper books to be prepared on arrival of the trial court record. Liberty to mention after 4 weeks. Yes. Statutory amount you have deposited. Yes, record an order. Learned advocate for the appellant is present. The application for stay is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of which is 25,000, there shall be an Identity order of stay of the judgment and award dated 6th March 2026, passed by Learned Additional District Judge, Fast Track Court, Durgapur, Posting Bardhaman, in MSCC number 61 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation amount, excluding the statutory amount, along with interest, as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. Service upon the respondents be effected personally as well as through the department by filling up necessary requisites and forms. Stop. The trial court records be called for at the special messenger post of the appellant to be deposited within 2 weeks. The informal paper books be prepared on arrival of the trial court records. Liberty to mention after proving. Yes. The Registrar General High Court Calcutta is requested invest the compensation amount in a fixed deposit.
54.
This thing should be that. First, there is no delay as deposited the statutory check.
Yes, learned advocate for the appellant company is present. The application for stay is taken up for consideration. So, as the appellant company deposited the statutory amount of 25,000, there shall be an additional stay of the judgment and award dated 30th March 2026, filed by the additional district judge, fast track court, Howrah, in MSC, case number 6 of 2023, for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation awarded, excluding the statutory amount, along with interest, as directed by the learned trial court within a period of 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the identity order of stay shall continue till disposal of this application. The Registrar General of the service of notice be effected upon the respondents both personally as well as through the department by filling up necessary requisites and forms. The trial court record will be called for at the special messenger post of the appellant to be deposited. Special messenger post of the appellant to be deposited within 3 weeks. The informal paper to be prepared on arrival of the trial court record. Liberty to mention after 5 weeks.
55. 55. What today? 55 today.
Yes, 55. Maladam for the insurance company. 58. This is Can 1. Yes, Can 1. Statutory deposit. Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of ₹25,000, there shall be an increase. Order of stay of the judgment and award dated 29th day of November 2025, passed by learned additional district judge, passed by learned judge, bench 5, City Civil Court, Calcutta, in MSC case number 225 of 2018 for a period of 5 weeks. The appellant insurance company shall deposit the entire compensation amount, excluding the statutory amount, along with the interest, as directed by the learned trial judge, within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the identity order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice upon the respondents, both personally as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special passenger cost of the appellant to be deposited within 2 weeks. The informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Big better, good one. I don't know to.
There is a case under section 163 capital. This is an appeal by the claimants. Learned tribunal judge for the death of a 34-year-old man awarded as compensation of rupees 4,58,300. 458,300. Not against that,
4,58,300
was the principals.
Yes.
With interest. While awarding the compensation amount, Learned tribunal judge held that the driver of the offending vehicle was not holding a proper driving license. It was an expired license. The Caesar list was there, issue was framed, and on the basis of that Caesar list, wherein the date of expiry of the driving license was mentioned, it was expiring in the month of June 2011. And the accident took place in the month of November 2011. So nearly 5-6 months prior to the date of accident, the license had expired. On that basis, Learned tribunal judge directed the owner of the vehicle to make payment, and insurance company was exonerated. Not being unhappy and agreed against this part of the award, on behalf of the claimant as per the appeal, appeal is on 2 separate grounds as of now. One, to give advantage of section 163 5 lakhs, make this 4,58,355 lakhs, and secondly, insurance company should be given the right to recover and make payment. These are the two-fold grounds of this appeal. This is confined only to this, nothing more. In order to convince your lordship, not change, right? Because as far as content is concerned, 5 lakhs. Then we are
just 30,000, 40,000.
40,000. That is the so I will not be disputing that. The first one, is in that to 5 lakhs.
So interest is awarded 8%.
We don't know if announcement is there, not to make it 6%, because that would be a risk. As far as the second part is concerned, exoneration to the insurance company and owner be directed to make the payment. But I would go by my learned tribunal, of course, not formally with formal objection. Which I lordship will kindly not be able to recover, and I will make the noting down my objection. I'll just indicate how a learned tribunal judge has come to this finding that the driving license was not there, it was invalid, it was ineffective, and it was rather it was expired. I just indicate those particular paragraphs to you. It becomes easier for us. First of all, I'll invite your lordship the written statement, page number 5. Page number 5, my lord would kindly come to. Paragraph 8, Miller.
Paragraph 8.
Lordship, at the top. Internal page 2.
Yes.
That the vehicle number so and so was in no way responsible. Was alleged to have been caused danger, and the driver of the opposite vehicle was not responsible. Vehicle in question was not being given by the driver, justly negligently. And then thereafter, if during trial it is found that the driver of the alleged vehicle had no driving license and the vehicle in question had valid permit, the said vehicle during the time of alleged accident, the insurance company shall not be responsible to indemnify the owner or to pay any compensation due to violation of condition of policy or at all. What happens when the claim application is filed? Within the stipulated time, we have to file our written statement. Your lordship knows because along with the claim application, the documents are never filed. So the insurance company is not aware of what is there, what is not there. That is why these defenses are taken initially at the time of filing. So that is there, that if it is found that the driving license is not there, or the permit is not there, or if the better particulars are not there, then insurance company would not be responsible. Then I will invite your lordship to this Caesar list, if my lord kindly comes to. Final report, which is at page 31. Page 3, one of my statement. On page 31, the award is also carrying on with 1 second. I have to put at page 16, 1 6. Page 1 6. One of them, at the very bottom, item number 10, serial number 7. The last, reference. Serial 7 of item 10. One driving license number so and so in the name of Mustafa, son of so and so, valid till 15th June 2011.
Yes.
15th 6 2011, and your lordship has perhaps taken note of the date of accident. It's 5th November 2011. Date of accident 5th November 2011, and the driving license 6 of Mustafa Milord was valid up to 15th of June 2011.
Yes.
Then your lordship will kindly come below to page number 28. It's a part and parcel of the award part of the tribunal. The award starts at page 27. I was inviting your lordship to page number 28. Page 28, second paragraph. The opposite party owner of the vehicle did not appear on notice and contest the case. The insurance company, OP2, contested the case by filing written statement, denying and disputing the statements made in the claim application and stating inter alia that the alleged vehicle was not involved, and that, your lordship will kindly take note, and that the vehicle was not driven by a person duly licensed to drive. So, my lord, award has taken reference to that. And my lord, the same page, your lordship will kindly come, my lord, at the bottom when the issues are framed, issue number 5. Was the vehicle being driven by a person duly licensed to drive it on the date of accident? So, my lord, my statement was taken note of.
So this went against the claimant and vehicle owner. It went against the vehicle owner.
Yes. And my lord, the finding of this, my lord, is at page number 31 of this award, my lord. And the tribunal has come to a specific finding. Page 31. Page 31, issue number 5. My lord, I was inviting my lord. Issue number 5, my lord. May I read? Though the owners did not appear to produce the driving license, my lord, they were served, they chose not to appear. The lordship is taking note. Though the owners did not appear to produce the driving license, certified copy of charge sheet shows that driving license number 42/78 in the name of Mustafa was seized in original, which was valid up to 15th June 2011. But I have shown that versus the distribution. The accident took place on 5th November 2011. Learned lawyer for the insurer submitted that on the date of accident, that is 5th November 11, driving license of the driver seized by the investigating officer of the connecting police station was not valid and it expired on 15th June. There is no ground to take a different view. I therefore hold that the vehicle was not driven by a person holding a valid license on the date of accident. The owner permitted the vehicle to be driven by a person whose license had expired. In the absence of evidence of want of negligence adduced by the owner insured, it must be presumed that the owner was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the conditions of the policy regarding use of vehicles by duly licensed driver of one who was not disqualified to drive under the relevant act. Insured owner did not adduce evidence to rebut the presumption of negligence against him. The owner has committed a fundamental breach of statutory condition. Your lordship knows not 149 statutory condition. The defense of the insurer must succeed. The upshot of this is that the owner and the insurance company who would be liable to pay the compensation as assessed by tribunal, and in the ordering part below, owner has been made liable to make payment. The page number 7, internal page 7, page 33, the last page of this award. The opposite party number 1, so and so shall pay compensation 4,58,300. So against this part,
Against this interest part, anyway,
just
vehicle owner has not come.
yes, vehicle owner has not come. So your lordship will kindly make this, since the claimant's appeal, since I take the responsibility, Your lordship will make it 6%.
Because whether shall I do it or because there is no appeal with regard to that 8%.
Without a cross objection in both the written since my lord is very uniform, in granting the administration and more so when I take the responsibility of it. So lordship will kindly make such person because I'll be giving her extra.
Because the insurance company is imposed liability.
Lordship. Milord, otherwise, I'll file no objection. Milord. You will be unnecessary milord in the proceeding, which my learned friend is not inclined. For this particular milord reason for such a trifle, milord, I didn't intend to, and I want to dispose of this.
Yes, anything to add?
There is.
So your ground of challenge is quantum as well as
6%.
Milord, the insurance company should pay and the liberty be granted to the insurer to recover it from them. So that lordship doesn't suffer. When the accident of 2011, milord, we are in 2026. 15 years have already gone. So let her get the money. The lordship will kindly preserve my right. And this against this finding, milord, owner is not unhappy. He is not before your lordship. He neither chose to appear before the learned court.
and although he served, he did not appear. In some cases, only this type of cases, owner service is must.
Yes, milord. That is why, milord.
Repeatedly, lordship, I asking.
Oh, he has entered appearance, but thereafter did not appear.
That is all the more reason the lordship can make. Unequivocal, milord, this order in my favor, milord, to state the proceed with the milord.
Yes, record and order.
I'm grateful to you, lordship.
Learned advocates for the appellants, claimants, and learned advocate for respondent number 1, Oriental Insurance Company Limited, hard learned advocate. The grievance of the appellants, claimants against the judgment and award dated 9th September 2015 passed by learned additional district judge, Third Court, HON'BLE in MSC case number 331 of 2014 is that the learned trial judge has awarded compensation which is inadequate. You have challenged the inadequacy of the compensation also. It is further the case of the appellants that the learned trial judge, in spite of the vehicle being insured, has directed the vehicle owner to pay compensation which is not paid till today. Stop. It is further the case of the appellant that the learned trial judge ought to have granted, ought to have directed the respondent number 1, Oriental Insurance Company Limited, to pay compensation to the appellant's claimants instead of directing the respondent number 2 vehicle owner to pay the same. No. Mr. Singh, learned advocate appearing for the respondent number 2-1 submits that as the driver of the offending vehicle was not holding any valid driving license, the learned trial judge did not commit any error in directing the vehicle owner to pay the compensation. Stop. It is held in different judicial decisions that where there is any violation of the condition of the policy of insurance, namely driving vehicle without valid driving license or valid permit, the insurance company shall pay the compensation with a right to recover the same from the vehicle owner. Stop. In the case of Leaders BB, National Insurance Company Limited versus Leaders BB, FMA 1003 of 2005, 3 of 2025. It was observed as follows, the blanket. In the case of Shubharani versus National Insurance Company Limited, it was observed as follows. It was observed as thus, considering different judicial decisions, this court is of the view that the learned trial judge may have directed the respondent number 1, Oriental Insurance Company Limited, to pay the compensation to the claimant's appellant and recover the same from the respondent number 2, vehicle owner. Stop. Further, with regard to the enhancement prayed for by the appellants, this court is of the view that considering the latest amendment of section 163A of the Motor Vehicles Act 1988 and considering the fact that motor vehicles claim legislation is a beneficial legislation, it would be just and reasonable to award compensation of rupees 5 lakh as provided under section 163A of the Motor Vehicles Act 1988. In the facts and circumstances, this appeal FMA 7
795 of 23.
So the paper book will find if okay. 795 of 2023 stands disposed. The judgment and award dated 9th September 2015 passed by learned additional district judge, Third Court, Baharampur, in MSC case number 430 of 2011 stands modified to the extent that the appellant claimant are entitled to rupees 5 lakh from respondent number 1, Oriental Insurance Company Limited, along with interest at the rate of 6% per annum from the date of filing of the claim case till today. The appellant, the respondent number 1, insurance company, shall deposit rupees 5 lakh along with interest at the rate of 6% per annum within 8 weeks from the date of communication of this order before Registrar General, High Court, Calcutta. So, the claimant's appellants will be entitled to withdraw the compensation upon compliance of necessary formalities. Stop. Upon depositing the compensation amount, the respondent number 1 will be entitled to recover the compensation amount from the vehicle owner in accordance with law by issuing notice to the vehicle owner and giving him an opportunity of being heard and following down the procedure as laid down in the case of Leaders BB versus National Insurance Company Limited, FMA 1003 of 2025. Thus, this appeal FMA 310 of 2016 stands. You know, with blank FMA.
I can remember the 3 is my opinion and 4 is my learned counsel. I prefer this appeal by law mainly on quantum and on root permit. Victim was aged about 50 years. It's an accident of dated 17th of July 2012. He was traveling in a bus, manner when not. accident of 2012. Victim was aged about 50 years, madam. He was aged about 50 years, madam. He was traveling in a bus when he met with the accident.
Yes.
As per the disability certificate, madam, issued by Arjikor Medical College and Hospital.
It's an injury case.
It's an injury case. My lord, as per the disability certificate issued by the Arjikor Medical College and Hospital, my lord, he had suffered disability to the extent of 68%.
Medical board.
Medical board, my lord, and it has increased. My learned friend has filed one application which is appearing in the. Actually, yes, can do, my lord. It says application. It has increased to 75%. The victim deposed as PW1. One person from Amri was treated at Amri, the manager of Amri. He came and proved the medical documents, one eyewitness deposed as PW3. I have the learned trial court, assessed the compensation on the basis of 12,000 rupees per month. My first round is income of the victim. It was assessed on the basis of 12,000 rupees per month. It's my ground that as per the income tax returns, my lord, the victim was earning around rupees in the assessment year 2011-12. His income was rupees 77,845 per annum. 77,845. Assessment year 2011-12.
That is why this 12,000 per month.
Per month. Now I'll be candid before my lord. This income tax, these income tax returns, my lord, two of them I have the copy with me, but they were not produced by us before the learned trial judge. But fact remains, they were part of the investigation report. But insurance company had not exhibited that. But I have those documents with me here and now, my lord. Fact remains that his annual income for assessment year 2011-12, my lord, it was 77,845. But the learned trial judge, my lord, consider 12,000 rupees per month. This is my first round. And thereafter, my lord, as far as the disability certificate is concerned, my lord, I will not. There's nothing much to depose in this. There's nothing much to submit, my lord, because it has
the income tax
lordship.
return file. The annual income was 77,840.
Lordship.
As per the income tax return file.
Yes.
But
for assessment year 11-12.
That was the prior to the accident.
Prior to the accident.
Okay. So that was, but that was taken into consideration.
No, we did not. We did not.
What is exhibited is.
We have not produced that document.
No, but they have produced.
They have not intentionally.
No, what?
That is why it's 12,000 rupees per month.
No, what was his occupation?
He was an advocate.
It can vary.
It can to the year before that, my lord, 2008-9, I have the copy of 3 income tax returns. In 2009-10, he earned 48,644. 10-11, it was 69,075. And in 11-12, it was 77,000.
So no income tax return was filed.
Intentionally. Because obviously the income will be less. So tribunal learned trial judge took the income to be 12,000. I'm coming to all the documents and evidence, but I'll just give a gist of my grounds. Thereafter, my lord, regarding the disability certificate, it was in the certificate, my lord, it was stated that it should be reviewed after 5 years, which my learned friend has already done. So the disability, it has increased to 75%, not much difference from 68 to 75, my lord. I leave it to my lord on that.
68 to 75.
I leave it to my lord. The third being victims. I have taken this ground. Victim's wife. She was in. She was working with the central government. So her family members, my lord, they were covered under the central government health scheme. But I must again be candid. This ground also we have not proved. So on the basis of it's an assumption that victim was also covered. He has received medical expenses. It's my ground that it should not be paid twice, since he has already got the benefit.
He was taken before the trial court.
No, I'm not. I'm being candid with you, my lord. And the other being interest, 9% default interest was granted. I'm humbly praying, my lord, that be 6%. Lastly, root permit, my lord. It was neither seized nor produced. So I humbly pray before my lord that my lord will be kind enough to grant me take due course of law against the owner of the bank. Now, lordship will kindly come to as far as the income is concerned, my lord. In the claim application, it says 12,000 per month. My lord will kindly straightway come to page number 71. In 71, my lord, this is the what had been stated by PW1, who was the victim, my lord, that he was earning 12,000 rupees per month. It's the internal page 4 of the award. The learned trial judge, my lord, at 74, first paragraph, dealt with the issue.
74.
Dealt with the issue of income, first paragraph.
Yes.
As per the claim petition, the injured Sri Vishwanath Mukherjee used to earn rupees 12,000 per month from his legal profession. And even during his evidence, he has categorically stated the same. Even exhibit same reveals that he has been enrolled as an advocate under the Advocates Act 1961 under the Bar Council of West Bengal. There is nothing to record or suspect or disbelieve the evidence on record in this regard, and the same may be safely relied upon. In my view, the claim of the petitioner with regard to his monthly income is honest and bona fide, and there is no scope to disbelieve the claim as claimed by the insurance company. I therefore conclude that the claim made by the claim petition with regard to monthly income of the victim is rupees 12,000 per month. So here, this one paragraph, it was dealt with. Now these are the, my lord will pardon me, my lord. These are the this income tax returns.
Oh, they were not exhibited.
Yes.
So at this
So will my lord be kind enough to grant me the opportunity to make one application before my lord?
this stage, you see. Anyway, I shall consider, because you got how many days, how many years this matter was pending before the trial court?
Award matter of 2012 award was passed in the year 2024.
So many years it was pending.
Just for my satisfaction, my lord, we kindly put this. Free returns, my lord.
Now you are it is a very reliability condition.
Let them say that it is not correct and it is not his returns. They knew about the returns, intentionally did not produce the same. My lord, we'll see. 2009-10, it's 48644, as I was saying.
Then future prospect, everything was
No,
pending.
future prospect was not granted.
So-
That will be get.
So question is, this is
Thereafter, in 2010-11, my lord, it's 69075. And lastly, 11-12, my lord, the relevant year, 77845.
it is 11, 12.
My lord, 77845.
But future prospect was not granted.
It will be 10% because he was 50 years.
Anyway, you want to go through this?
Let it our process.
No, what is your ground of challenge?
But I am not challenging.
No, ground of this
Future must have been and my interest has not happened.
interest?
Interest has not been awarded.
No, awarded.
No, for now, in default case.
Okay.
And what a future, and the future person has to be awarded. March, most of the.
I mean,
Yes.
um, so this is as far as the income is concerned, madam. Now the route permit, as I was saying, my lord will kindly come to the Caesar list. It is at the chart sheet, my lord. The chart sheet is at page 20. Page 20, my lord is.
Yes.
It says the property description, my lord, Caesar. It says one offending vehicle and connecting papers of vehicle number such and such with driving license as per the Caesar list. The Caesar list, my lord, is, I do not have a copy of the Caesar list and it was not exhibited. So,
Regarding driving license and permit, your
permit. It was neither seized nor produced.
what was the Caesar? What was the article that was seized?
That is not clear.
Which page is your investigation report?
The investigation report, of insurance company,
Yes.
that had not been exhibited. It's not part of the records.
But it was carried. Yeah, have you added any evidence?
No.
Total compensation awarded?
12 lakh 9,722. 1209,722. To pay within 2 months. 1209,722 to pay within
12,09,722.
mine. To pay within 2 months in default 9% interest. And this award, my lord, it consists of the multiplier. It was assessed on the basis of 68%. And 1,32,000 and odd was given for medical expenses. It was proved, it was given. So this is it.
Yes, what is it?
Well, I'm sorry, just this additional written statement, my lord will kindly keep it with my lord. My lord, regarding the permit, my lord, I've taken.
You have filed additional written statement.
Yes, I have filed, but it's not part. I have missed annexing this in my paper book. Lord, will kindly keep it with my lord's record, my lord.
So you
I've taken the ground of.
investigation report was, they are not exhibited.
No, we have not produced it before the learned trial judge, but we have taken the ground that the permit, it was neither seized nor produced. Regarding the minor that the spouse is also covered the central government scheme of health bima, we have not.
You have not
Lordship.
Yes.
So far as the income. Maybe the return of clearance. I am okay with this. For the molecular legal practitioner, you will say per month, they are to claim. But it is senior.
No, this is
Last one is not actually that will 11 claims.
11, 12.
Not financial year 10 11. Diet actually took place on
July.
July 2012. So it is financial year 12-13. For the financial year not 11-12, there is no income tax. There is no taxation.
Which year?
Yes, yes. 11-12. This is the last one, the not taxation for the financial year 11-10.
The accident took place on
7th of July and 19th of July 2012.
17th July 2012.
It is the financial year.
7th of July.
19th of
17. 1-7.
July
2012.
2012. And the question is, this return is 11-12 or this thing 10-11?
11-12 is assessment year.
11-12 is assessment year.
Not financial is 10-11.
10-11.
Ended on
So this
31st
is
of March.
this is 10-11. Previous year, you see, assessment year is 11-12. And this is of 10-11.
10-11.
That is 77,000.
77,000. But just not before this not
45 is assessment year 10-11. So financial year 10-11.
financial year 10-11. It comes to be ought to be considered not for financial year 11-12.
Yeah.
So the accident formula of the financial year 11-12 has not been applied. So in my words, my humble submission was for a senior advocate, a legal practitioner, income of 12,000 per month in the year 2012 is quite reasonable. But Lalit, Jamuna estimate the completion on the basis of the claimed amount of 12,000. But in my view, not there is no law done by the law. And when Lalit tabular law did not consider the future prospects. Optional person note will get 10% future prospects. Motion law, no amount is allowed. Course not non-pecuniary.
No, this medical, not this pain and sufferings. No. What is your ground of challenge? Only pain and only this future prospect or this non-pecuniary damage?
Challenge the future prospects. Interest has not been
No. Future prospect, any other, this pain and sufferings.
One thing that I have valid after the accident lot, the claimant has lost his total income, 100%. It's not in a position to not carry on this profession. This could not come till that date. Till date of not
This is your cross objection.
last page 83.
No, regarding 75%, did you adduce any further evidence?
I have not filed application.
No, this is your application. Your learned friend has also filed application for adducing evidence.
But
So this is also
if I forget for 75%, no, you have to calculate this. take it 68%.
Yes, because if both are considered, then both, if one document is to be considered, the other has also to be considered.
Documents are fine.
Okay, 10%, future prospect is not awarded.
It's not ever. I'm not if a professional person could not join his profession, so income loss of income to be taken as 100%.
So he is a practitioner of this court or Ali court? Yes?
What is going to work freely and his working ability has been reduced almost to nil. He could not go out of the residence without assistance.
So if future prospect is taken, how much it comes?
10%. People take the income, whatever maybe. It will be added 10%. Some amount will be allowed in was not non-pecuniary debts.
But you have not challenged that.
I have not challenged, but learned that
Yes, record an order. Learned advocates for the parties at present are learned advocates. Hearing is concluded. Let this matter appear for judgment on 20th July 2026.
We have not made any calculation, but.
For the 10%,
One will
I shall consider that.
deep your judgment.
was a question.
I have not filed any application for additional evidence under reducing. Those were there with me, as per the investigation.
I'll record your submission.
I'm extremely.
There are some chances that perhaps from 2 minute discussion had long
PM is, yes,
that the Deepak the square silent
Deepak, they,
no he used to the criminal matters
Deepak Sengupta, former president of this
yes,
association.
yes, he had expired. So we have got a meeting at 1:25. I have been told, of course, orally, that there is a chance that perhaps from 2 o'clock, perhaps.
So the bar may not attend.
The bar,
Or
I was just
tomorrow
thinking-
the effect can be given also.
But today's at 1:25 is the meeting. I was just indicating to you, whatever this.
So at 2 PM we can get the information.
By 1:30,
Anyway, give information at 2 PM. So after that I shall sit.
My
Anyway,
maybe at 3:30 also, I do not know, but let the decision be
so
taken.
when did he die?
Today morning.
Ooh,
Yes.
then you see this cremation and all this last rites, these are not yet performed. So members may be busy there also.
We got the news today morning.
Oh, we got the news. That means it may be 1 or 2 days.
Maybe yesterday also. Maybe yesterday also.
Meeting is there.
Meeting is in the lunch.
Thereafter, the intimation will be given. Anyway, if there is a bar,
Intimate to my office.
yes, if there is a bar resolution, if both parties do not accept it, no matters will be taken up. And
And he was very respected.
yes, very eminent member of the. The last few years he did not come to
Last
court.
few years he was not. He was not.
Yes.
He stayed at Bull Park.
I met him also for 2 years ago. Anyway, let us see. And it may happen on Monday.
maybe, my lord, we do not, I'll go there.
Okay.
Let me finish.